Hi, everybody. I thought I would just give an update on a few things that have been happening other than the US election lately. The first is what's going on with Bola Tinubu. If you're not familiar, Bola Tinubu is the president of Nigeria. He's also a former money, excuse me, a former money launderer for a narco trafficking ring that was based in Chicago in the early 1990s. So Mr. Tinubu is the subject of a FOIA lawsuit that I filed probably I think more than a year ago now, and it's sort of been plodding along. But there has been some movement. On September 12th, I believe, I filed what's called a motion for summary judgment. And what that means is that there are essentially no legal issues left in the case to, sorry, no factual issues left in the case to argue about. All that's left is the legal issues. And so what that means is that you submit a motion to the court saying that you'd like to get these issues resolved, uh, just based on the fact that all the facts are sort of agreed upon at this point. And so, what that involves is showing that, in this case, there was actual official notice that Bola Tinubu, or official acknowledgement, I guess is a better term, that Bola Tinubu was involved in this narco trafficking ring. And that came in the form of the 1993 civil forfeiture case in which the IRS, DEA, and the FBI all said that they are investigating him and they have all these details about him, everything from his Nissan's VIN number to the name of the shell company that his associate, Muiz Akande, was using, GlobeLink International. And so, this is something the federal government officially put out in front of the world saying, we know all this stuff. So for them to now say, well, we never talked about it is, I think, a bit disingenuous. So that's one major issue. Another issue that comes up in this motion, which you can read on plain sight if you go to the case docket, which will be in the description for this video, is that one of his associates and Akande's associates, Abiodun Agbele, was actually, his name was mentioned in one of the last FOIA disclosures that the FBI produced. So they had been redacting everybody's names that were involved, it seemed, for the entire time. And at the very last minute, they produced one page that said the name Agbele. And as soon as they do that, that's also basically an official acknowledgement that he's been involved. And so what I'm asking is that they go back and look at all those other redactions they made to make sure that they didn't unnecessarily redact Agbele's name in other places. So the government has until, I believe, sort of mid-November to reply to that motion for summary judgment with their opposition. And then they will probably file their own motion for summary judgment. And then I reply to that one. And so this is all going to probably get, finally briefed by both sides in front of the court in early 2025 in January. And then it's who knows how long it'll take for the court to resolve those motions, but hopefully, not more than a couple of months, I would guess. So we're looking at like early 2025, maybe March or April. I would hope to find out when this gets resolved. Um, Moving on to other news, back in the United States, there was a court opinion that came out this past week in a lawsuit about the Tesla FSD, supposed full self driving technology, where investors had sued, arguing that Tesla had misled people about FSD. So this is a fairly important case. It's not the only FSD case, and there have been others in the past. Like there was a case in Santa Barbara County, California, where a California judge ruled that it was plausible that under California law, the company had engaged in false advertising. This is a federal class action lawsuit about securities, so it's not the same law. It's under federal law and it's under the PSLRA, which is now my favorite topic. If you've seen any of these other office hours videos, you'll know that I've talked about the PSLRA in the past. For those who don't know, it's the Private Securities Litigation Reform Act, and it's this law that basically nobody knows about that makes it impossible to hold corporate executives to account. And it's sort of rearing its ugly head again here. So the case is called, I'm going to pronounce this incorrectly, I'm sure, La Montaña versus Tesla. and Thomas LaMontagne is the lead plaintiff, but again, it's a class, so there's a lot of people involved. And there's a lot of things about this opinion that I find surprising and that I would say I don't agree with. Uh, and a lot of people have sort of, I guess, conspiracy theories about Elon buying judges and everyone being in his favor, and it's just sort of a I don't know, an attitude of not quite nihilism, but maybe just I think people might be giving up that there could ever be any accountability. And I don't think this judge is bought. I mean, I think this is a fairly new judge in the Northern District of California. Um, Her name is, and I'm going to mispronounce this as well, Araceli Martinez Olguin, and she's a Mexican American judge. And I mean, I don't know much about her, but I would guess that given Elon Musk's comments, which are, I think, largely derogatory towards immigrants, I doubt that she would have any extra sympathy for somebody making those kinds of remarks. But nonetheless, she has written this fairly um, positive opinion for Tesla, where they basically seem to have convinced her on every point. So um, the first thing that I think is important to realize about this case is the way in which it frames the FSD debate. So, anyone who's been following Tesla's claims and Elon Musk's claims about full self driving might be aware that there are these levels that engineers use to assess the functionality of autonomous driving systems. And there's level one, which is basically it doesn't do much at all, to level five, where the car can drive you on its own with no intervention and no supervision, and it's just sort of this kind of magical robot. Um, and you know, the middle levels, two, three, four, especially two and three, they get a little bit hard to parse because it's difficult to draw the line as to when something is autonomous and when it's not, and what features are involved and how you describe those. So, Tesla has been saying that its system, at least in communications that I uncovered to regulators at the California Department of Motor Vehicles, Tesla has been saying its system is level two, which means that the DMV cannot regulate it because the DMV only starts regulating systems at level three and higher. And so then there's this question about, have they been saying that because they don't want the system to be regulated? And by calling it level two, that means there's nothing DMV can do about it. And the same goes for NHTSA, possibly the federal regulator, the National Highway Traffic Safety Administration. So there's this question about, okay, well, they're saying it's level two, but is it really? And if it's not, what level is it? And meanwhile, Elon Musk has been telling the world repeatedly that it's a level 4 or 5 system if you just wait long enough, maybe next year, and he said that repeatedly. So this case frames the debate in terms of Tesla promising through Elon Musk's remarks that FSD is going to be level 4 or 5, but it never has gotten there, and therefore those statements about it being level 4 or 5 have been misleading, especially it says because Tesla has not even gotten to level 3. That's not the only way to frame the debate. In the lawsuit that I've filed, uh, I think it's more interesting actually that they've been calling it level two when it actually may be higher than that, and when it may be a more advanced system based on how they're marketing it than they're claiming. And so it it's a different kind of misleading statement then. In that case, they're misleading regulators as opposed to misleading the public, although you could argue that they're actually misleading both in different respects depending on the context. So, with that background, reading through this legal decision, what's interesting to me is that again, the PSLRA is what's guiding the court's sort of evaluation metric here. The standard upon which the judge is looking at the claims in the complaint is all based on the elevated pleading standard in the PSLRA, which means you have to be not just super specific and know like every fact in advance without the benefit of discovery from the other side, but you also have to know the defendant's state of mind and basically prove a priori that they had criminal intent when, it's very hard to ever have facts that get into somebody's state of mind. Of course, this is all deliberate on the part of the Republicans who passed the law, and this is why it's so difficult to get a securities case. Even one I should mention here, where the plaintiff is not some pro se litigant who's never seen a court before. This is a case where the complaint was written by experienced securities attorneys, lots of them, and so it's not as though these people were unfamiliar with the system. It's just very, very difficult to get a PSLRA claim to go through. So the first issue that comes up is that one of the things the PSLRA does, and I think more people are probably familiar with this part, they just don't know where it comes from, is that it sets up this exemption for false claims for forward-looking statements. So if you're telling people something you think will happen in the future, but you're not sure, there's what's called a safe harbor, where you don't get in trouble for making optimistic statements about the future, because that's kind of something companies do all the time. And often it'll turn out that maybe you're a little bit too optimistic, but things are generally fine. The congressional intent, I guess, was that we don't want lots of lawsuits about sort of routine statements. However, there is an exception for the exception. So there is a statutory exclusion from the safe harbor. And basically, if you've already gotten in trouble for violating securities law, then it can be argued that you are no longer entitled to the safe harbor, because you've already shown that you have a tendency to sort of make these remarks when maybe your intentions are not actually as good as one might hope. And so the plaintiffs in this case were arguing that Tesla should be excluded from having the benefit of the PSLRA safe harbor. Um, they lost on that. The judge ruled that Tesla still gets to use the safe harbor. Uh, and she ruled that the SEC consent decree that the company signed did not count as sort of I guess, a ruling or a order that involves fraud, which I don't agree with at all. I think it completely is intended to prevent further securities fraud, but that's what the judge ruled there. There's been, I think, a lot of discussion on the internet about how this complaint also gets into the issue of corporate puffery, whether the FSD statements were just, quote, mere puffing because they sort of make grand claims that no one would actually believe. And this gets into the whole sort of like Fox News, no reasonable person would actually believe any of this stuff kind of defense, which is pretty pathetic. I think a lot of reasonable people have actually believed Musk's and Tesla's claims. Um, and then there's another part here, which, even beyond the puffery and the safe harbor decisions, I think is problematic, because it seems as though the judge is arguing that um, the plaintiffs don't allege in the complaint that Elon Musk was really involved enough with FSD and autopilot to know that maybe he was misleading people. And I think that's actually a pretty outrageous uh, statement to make in a judicial decision about this issue, because first, I think it was alleged in the complaint that Elon knew, but second, there is so much evidence out there that Elon Musk not only knew what the autopilot department was doing, but he was in charge of it and is in charge of it. And they would have weekly meetings, and he would be at those meetings, and he ran the email accounts that, I think, if they have like an email listserv within Tesla for the autopilot team, he's the administrator for that. And there's all these facts that maybe some of them were in front of the court, maybe some of them weren't. But I think it's a little bit shocking that a court would rule that he was just too distant from any of this to know what he was really saying. On top of that, there are confidential witnesses. So these are generally former employees who testified to the plaintiff's attorneys, saying that, this was known to be misleading within the company, and the judge dismissed all of that as well. So it seems like she really bent over backwards to do Tesla a favor in this decision, and she did give them the ability to amend the complaint. So we'll see what they come back with. If they file an amended complaint, they have until October 30th. But it was disappointing to see this because I think there's a lot of factual issues and there's a lot of legal issues with the opinion. It's possible we'll see it go to appeal, but I hadn't seen a lot of in-depth analysis of what was written here, so I wanted to mention a few of those things. And then the final topic, and if it looks like I'm sweating, it's because we're in the middle of a heat wave here in San Francisco. Um, Final topic is Elon's abuse of anti-SLAPP laws, which is something that has come to my attention because in the lawsuit that I filed against Tesla and Musk and various others, there have now been a total of 6 anti-SLAPP motions filed, 3 for the initial complaint and 3 for the first amended complaint. And I now know of, I think, 4 cases where Elon Musk or Tesla have invoked the California anti-SLAPP statute in a way that seems abusive. And so those cases are Hoti versus Musk, where Randeep Hoti sued Elon for libel, and then Elon responded by filing an anti-SLAPP motion. There was a Taylor versus Tesla case where Tesla filed an anti-SLAPP motion. There's the Don Lemon case where Don Lemon sued Elon Musk and X Corp after their agreement for him to be a sort of X Corp correspondent fell apart, and Elon responded with an anti-SLAPP motion. And then there's my case where Elon and Tesla, as a group with other defendants, filed an anti-SLAPP motion, and then X Corp filed its own anti-SLAPP motion, and then Morgan Stanley filed an anti-SLAPP motion. So I'm not going to hold Elon accountable for Morgan Stanley's legal decisions directly, but it does seem like there's a pattern here of Elon Musk filing anti-SLAPP motions in many, many cases, and these are just the ones that I am aware of, where he really has no grounds for what that motion would call for. So if you're not familiar, SLAPP is SLAPP. It's a strategic lawsuit against public participation. And California arguably has the strongest anti-SLAPP law in the country. The point of these laws, where they exist, and it's all on a state by state basis, there's no federal anti-SLAPP law, is to prevent people from abusing the courts. So if you go into court and you sue people for saying things all the time, that's generally considered a waste of everyone's time. And so there's a law to prevent that kind of abuse. And I think it's important that those laws exist. I don't like it when people file frivolous lawsuits, especially ones I have to deal with. So I'm fully in favor of there being an anti-SLAPP statute, but there's always the risk that the law that you're passing will itself be abused. And so here, I think it's arguable that there's abuse of this law going on by a billionaire who has a lot of lawyers at his disposal and has effectively become himself a vexatious litigant, even though he's represented. So it's fascinating to read, especially the opinion in Taylor versus Tesla, because it starts out with a very short paragraph. In this Private Attorneys General Act of 2004 PAGA action, Tesla Incorporated appeals from the denial of a motion under the anti-SLAPP statute. Seeing no merit to any of Tesla's arguments, we affirm. That's how the opinion begins. And it goes on to outline what happened in the case. This is one of these labor lawsuits where Tesla employees sued because they were being mistreated in one of Elon's many factories. And in the process of them suing over their mistreatment, Tesla basically refused to hand over discovery documents. And they argued in their anti-SLAPP motion that their refusal to participate as required in discovery was a violation of the company's free speech rights because they had chosen, in this case, they argue, not to speak. And the appeals court did not find that to be a compelling argument, to say the least. So they upheld the lower courts, the superior courts, denial of Tesla's anti-SLAPP motion, and they wrote a fairly scathing argument as to why Tesla is wrong. So in that case, Tesla lost, uh, and you could argue indirectly that Elon lost. In the Hoti case, Elon also lost. The California Court of Appeals there ruled that even though it might be an issue of public interest, and when you file one of these motions, you have to be talking about an issue of public interest. You can't just argue that anything is anti-SLAPP. You have to argue that there's speech involved that really goes to some important issue, like if you're at a town hall and you're talking about something happening in your city, or you're even on the internet and you're talking about a hotly debated issue, maybe the election. Those would be issues of public interest. But they look exactly at the speech that's being made, and they try to say, is this public interest or is this not? So um, in the Hoti case, it was argued that Elon Musk referring to Randeep as having almost killed a Tesla employee, which did not happen, was not a public interest issue because you can't just make stuff up and have that be public interest. So um, it's something to look out for. If Elon continues abusing the anti-SLAPP statute, I think it's worth, raising the issue with the California legislature to see if there should be additional exemptions for the law because currently there are two exemptions for commercial speech, which is fairly narrowly interpreted, and at least in some cases. And there's an issue for public interest, but I think both of those exemptions should probably be broadened to prevent this kind of abuse. So stay tuned. We'll see how that all turns out. In the meantime, there are a lot of other lawsuits pending against Mr. Musk and Tesla. And so even though the Lemontine decision isn't particularly factual or I think legally sturdy, that it's not necessarily the end of the story there. So uh, stay cool and enjoy the weekend. Thanks.